Good morning. We'll call the September 13th Crow Wing County Board of Commissioners meeting to order. If you join us for the pledge and a moment of silence.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Next on our agenda is open forum. If there's anybody in the audience that'd like to speak towards something not on today's agenda, please come forward. State your name, address for the record.
My name is David Blair. I live up on the Carlson Lake Road in Crow Wing County. And my question is, with the BIR, the noise level with the band after hours is not acceptable. I'm a working man just like every other tax-paying individual in this county. And when it's banging so hard, it's not that you can hear it. I'm 2 miles from the track and I can feel it. My son sleeps in the basement bedroom and he woke up because he could feel it. I was told by the sergeant that there's nothing that they can do because there's no statute of sorts for the noise levels coming from the bands at BIR. Now you have thousands of people up there that are not from around here, and us tax-paying locals have to suffer. So I'm asking, they said it was a permitted event. Who fills out that permit?
Tim.
Mr. Chair, Mr. Blair, I think what you would find is that racetracks that were built prior to, and forgive me if I get the date wrong, 1976, are exempted from the state's noise standards. That's the issue with BIR, is it's not that there is a law that doesn't apply, it's that there is a law and they have been specifically excluded from the state's noise standards.
So you're telling me the non-local people come in here to make a buck, and us tax-paying citizens just have to sit back and take it?
I'm not telling you that at all. I'm telling you what state law says. State law says that a racetrack built before 1976 is exempted from the state's noise standards. We didn't do that. That's state law. We didn't do it.
They didn't do bands back in 1976 that kept everybody awake.
I understand, and I understand your frustration.
Running cars doesn't bother me. I'm talking about the noise levels after hours from the band that I can feel, not just hear.
They're exempt.
Does that, Tim, include bands, or is that just the race car
noise standards applied to a racetrack built before 1976. So it does not specifically say racing events. It says a racetrack built before 1976 is exempt. I'm not trying to diminish.
I understand we're just rocks and cows up here, but we are paying citizens, tax-paying citizens and law-abiding, and we would like the laws at least looked at to address this issue so that I was told by a sheriff's deputy yesterday that, well, you can take it to your county commissioners, but you'll go nowhere, or you can move. Okay, does somebody have $1 million to throw at me so I can get my hinder out of here? I'll move someplace else. Anybody?
You're looking for county government to solve the problem.
I'm looking for the county to
Sir, let me finish, please.
Something.
Can I finish my sentence? Can I?
Yes.
You're looking for the county board to solve a problem that is written into state law. We can't change state law. County boards can't change the state law. Only the state legislature and the governor can do that.
So in other words, I need to talk to like Josh Heinzman and those guys.
Right.
We don't have any authority to change it. It's not that we don't want to try to help you or try to help deal with your concerns. It's that we don't have any authority to do it.
Well, just respect for the citizens of Crow Wing County. If they would turn it down a little bit, everybody would be happy. That's what I'm asking for.
And I will call them,
Well, honor,
call
Mr.
them and let them know.
local citizens.
Mr. Chair, if I could, I too, I have a good relationship with the track owners. I will call, and we do have a gentleman's agreement that is not enforceable, but that they work very well with us. And I will pass on your concerns. And this map races that was happening this last weekend was one of the bigger races for the younger racing crowd, i.e., why the bass and the big thumping and everything else for the radios and bands was so loud. My follow-up that I can do and I will do is work with Christie. I'll make a phone call yet today and advise her that our ask is to ensure that the midnight is the time of when the loud music starts. Now, Dave, you did say Saturday at midnight it did
It's
stop.
when I called. They had a permit till 1 a.m.
And that's,
Now, I will have to say, I give them kudos for Saturday night. They turned the volumes down for Saturday night. It was tolerable. There was no feeling it in my house 2 miles away. When I picked up my daughter from Craigens from work, I could hear the band, which is like somebody having a radio in the next room. Okay, I can hear it, but it's subtle, not disturbing.
so I will certainly make that phone call and we'll try to ensure that, that it is an earlier time for the obnoxious
If
loud.
they want to play till 1 a.m., but turn the volumes down so it's tolerable for the citizens of Crow Wing County, then everybody wins. Thank you.
Who permits those?
Thank you.
Who permits those?
So David made mention to permits and also that our deputies had made reference to permits. I'm not aware of anything out there. I think there's just a miscommunication there because like what I shared with Dave, I'm aware of no permits, no special restrictions, and as we may recall, this goes all the way back to Donnybrook. I mean, decades ago, and there was never really any restrictions or standards besides the state standards that Tim mentioned that they need to follow for time guides or anything else. A lot of it has been gentlemen agreements of when they will start, like their fuelies. They won't fire the big race cars till 9 a.m. That's an agreement. That's no more than there's no law or ordinance against that. It's simply that's their agreement. They won't start the big cars till 9 a.m. to allow people to sleep. And like I said, we've got a good relationship. They don't want to. They want to be a good neighbor, and it's tough sometimes to get that many people, but I feel confident that working with Christie, she'll correct this action.
Thanks, Scott. Anybody else here for open forum? Seeing none, we will move on to the review and approval of August 23rd, Crow Wing County Board meeting.
Make a motion to accept.
Second.
We have a motion by Commissioner Barrows, second by Commissioner Franzine. All in favor?
Aye.
Opposed? Motion passes. Review and approve today's agenda. Any additions?
Motion to approve.
We have a motion by Commissioner Franzine,
I'll second.
second by Commissioner Brecken. All in favor?
Aye.
Opposed? Motion passes. Consent agenda. Any questions, comments, concerns?
Motion to approve.
Motion by Commissioner Franzine,
Second.
second by Commissioner Barrows. All in favor?
Aye.
Opposed? Motion passes. Community services. Jake. Good morning.
Good morning.
Morning.
Mr. Chair, and members of the board, I am Gina Heyer. I am the Community Health Manager for Crow Wing County Community Services. I am accompanied by Jacob Fry, who's the Environmental Services Supervisor, and we have been working together on a case for a public health nuisance abatement. As you can see above, the address is on the 29,000 block of State Highway 6. And upon investigation of this property, we did find a public health nuisance exists. Do we have a closer? Thank you. As you can see by these pictures, public health is concerned with the tires and the household waste that is on the property. And we have, we're here today basically to ask permission to move forward with abatement of this issue. The property owner was notified both in writing and in person, verbally, of the need for abatement, and he did not comply with the dates and the deadlines we gave him. We have been working with a contractor and secured a bid for the cleanup and would like to move forward with that process.
Mr. Chair, if I might, so there's been no response back from this
He has responded.
to say that he doesn't agree with it, or?
He did attempt to clean up some of the items, but not enough of an attempt was made to deem it satisfactory to drop the abatement.
Okay.
Mr. Chair, I would move the request for board action on this public health nuisance abatement.
Second.
We have a motion by Commissioner Coring, second by Commissioner Franzine. All in favor?
Aye.
Opposed? Motion passes. Thank you very much.
Thank you.
Thank you.
Facilities.
Good morning, Mr. Chair, Commissioners. We've had an unexpected failure of the hot water heater at the Central Services Building. It is it's a large water heater. It's 100 gallons, quick recovery, high efficiency. The request for action today is for funding to replace that failed water heater.
How many, Mr. Chair? How many gallons?
It's 100 gallons. It's a big water heater. It's a high
100?
efficiency, and it recovers at 240 gallons per minute, so it really goes. So,
That doesn't seem like a very big, 100 gallons?
I've got a bigger one than that in my house.
no, it works. It works. So I have a 20-gallon in my house, so to me, 100 gallons seems like a big
120.
number.
So what does that all operate? Which buildings?
Just Central Services, but
Okay.
it's used back in the sheriff's garage to preheat the water for their decontamination station. We use it to clean the cooling towers, clean up the snow and ice and salt off our tractors and stuff and our landscape equipment. So it gets used a lot. It's very active.
Could I ask another question? So how can it be $20,000?
Well, it's $18,000. That includes an expansion tank, installation, removal of the old water heater, and we have to put in a new flue. We have to send a 3-inch combustion air line up through the existing 8-inch flue. So
Is it gas?
it is gas.
Because, you know, I don't have an off-peak hot water heater in my house now, but I used to have like 120 gallon. It was like, because, you know, you got to have enough capacity because it heats it up only at night. I don't know. I don't know. Seems like a lot, but I guess it is what it is.
It is a lot.
It is a
I
lot.
don't disagree. But there's a lot of, there's an expansion tank involved and installation.
It's a commercial water heater
It's- oh, yeah,
rather
it's
than
a
a
hot-
residential,
it's a
which
commercial.
is much more spendy than. All right.
Chair, if I might, I'll make the motion to approve the expenditure to replace the hot water heater at Central Services.
I'll second.
We have a motion by Commissioner Barrows, second by Commissioner Brecken. All in favor?
I
Opposed? Motion passes.
Thank you.
Thank you. County Sheriff.
Mr. Chair, Commissioners, I do not have anything prepared, but I'd certainly be willing to answer any questions that you all might have.
Any questions for the sheriff? Got by easy today.
Thank you.
County Attorney.
Mr. Chair and members of the board, the only thing I have before you today is as requested, I've brought I still call it the Nelson Preserve Cartway. It has a number of different titles, but still it's the Cartway petition that's been pending here for some time. The last time we were in front of the board where actually any action was taken was May 10th of 2022. At that time, Trish, do you have that map that I made sure you had yesterday? At that time, Route 2 of the map that was up there was the route that was selected by the board. As I recall, there was a motion to that effect, and the motion carried. I don't know if that is still going to be the board's wishes or not. We have not finalized these proceedings, so you are able to change the route should that be a decision you want to make. I'm not suggesting you should or shouldn't. I'm just trying to give everyone an update. In preparation for today's hearing, anticipating that we may just go forward with the damages issue, asked Gary to update the estimates from Land Services, and yesterday he did so, and I think provided a copy to Tim, and Tim provided a copy to you, and there are copies out on the board. And I see that Therese has that up on the screen right now. This deals with the damages to the Unger property. It's my understanding there are easements that have been acquired up to Mr. Unger's driveway, though they are not recorded yet. I'm assuming Mr. Kruger is present virtually today, because I don't see him
No,
here.
he's sitting right in the back.
Oh, he came in. Sorry, Pat, I didn't see you there. I'll let him speak to whatever he wishes to speak in regards to his client's position. And I can let Gary speak to the damages that, estimates that have been provided to the court. I think that tees it up, Mr. Chairman, for discussion and board's consideration of what, if anything, they wish to do today.
Okay, thank you, Don. So we've got both sides' attorneys here. If you'd like to comment on anything, we would hear those now.
Thank you, Mr. Chair, members. My name is David Myers. We met before, and I represent Keith Unger. Could you put the mapping back up there to begin with, please? As Mr. Ryan said, you tentatively have chosen Route 2, and as he also said, everything is open on a cartway until you sign the final order. Mr. Unger would prefer not to have a cartway, but he knows the law and he knows what you have to do, and his preference is for Route 1, which takes them to the significant part of their property. You don't, in a cartway, have to provide access to every part of the property. If you did, we'd be looking at 2 cartways here, both Route 1 and Route 2. I provided, and I have a copy here if you wish, in anticipation of this, last year, we obtained a technical report from Wink and Associates. These are environmental consultants, about where is the least environmental harm between Route 1 and Route 2. And after some serious and extensive investigation, they've decided that Route 1 is the least harmful because Route 2 has old-growth trees right where they want to put this cartway. And in your comprehensive plan and in your ordinances, to the extent you can, you tell your citizens, leave the older trees alone if you can do that. In fact, Route 2 falls into an area in your comprehensive plan and your zoning ordinance called a shoreline protection zone. It's within 500 feet of, I think it's Nelson Lake, which is an environmental lake. And you tell your citizens and you tell your property owners, if you can avoid substantial tree cutting and vegetation disturbance and construction in that shoreline protection zone, you should do it. It's not mandatory. I'm not saying you can't put a road in there, but you tell your people that if you can avoid going into those protection zones, you should do that. And I'm asking you to set an example. If you're asking others to do it, you should do it yourself. Route 1 is outside of that shoreline protection zone and not covered by the ordinance. It's within the shoreline buffer zone, but it's not in that sensitive area. And as I understand where they want this cartway, it's sort of a ridge, not a bluff, but a ridge. And again, if you're going to tell the rest of the county that you need to protect trees and ridges and so on so they don't impact the lake, then I think by example, you have to follow what you're asking others to do. Either way, you need to set damages. And when you set damages, when you take highways, when this county board goes out to its citizens and takes road right-of-way, you get appraisals. You don't go to your staff and say, well, what do you think it's worth? And you don't go to the property tax statement and say, well, you know, you got an acre here and it's worth $40,000 and we're taking a couple hundred feet out front, so we'll just give you some fraction of the $40,000. You have to get appraisals. This is how you treat your taxpayers. You don't go to your taxpayers and say, we'll make it up as we go along. We got to get appraisals. You don't get appraisals?
We make offers based on the appraised value of the property that the assessor has. We only get an appraisal if there's a contested case.
Such as this, it's a contested case. So that's what I'm talking about. Yeah, if you can make deals with people, yes, absolutely, that's what you do. And perhaps that's what the petitioner did with the others on the Cartway up there. But when you have a contested case, you have to get an appraisal. That's how it is. So we went out and got appraisals, and again, I'd be glad to share this with the board, but we have 2 appraisals, and these are the only appraisals you got. Nobody else prepared one. It took me a year to get these appraisals. They're not easy to get. It's difficult to find appraisers. Like everybody else, they're all busy, and this is a very difficult part of the county to get comparables in because you don't see many roads being built out there. So this is what you got. So for Route 1, at the top, based on the damages, that the land taken and the harm to the remaining property, the damages are $63,000. That's what you would have to pay based on this appraisal if you wanted to put a road in there, which is what you're doing. In fact, you'd pay more because you're probably putting a 66-foot wide road in there. This is only 33. But nevertheless, this is all you got for a value that's based on a appraisal to take the land. If you go to Route 2, the value is $125,000 because you're closer to the house, you're closer to the lake. So that's that is the only legal unbiased basis you've got to determine damages. Route 1, $63,000, Route 2, $125,000. Yeah, it's a lot of money, but they're asking for a lot. And in your case, you don't get to, when you try to condemn land from a property owner because they're not negotiating with you, you don't get to say, well, we want to do this road project, and we're going to do the road project, but this is way too much money, we're just not going to pay you that. Sorry, we're going to move on. You have to pay the appraisal. That's what you got to do. You can't, in this case, I believe, treat this petitioner better than you can your own taxpayers. Your taxpayers have to pay appraised value. If he wants the Cartway, that's his choice, then he's got to pay the appraised value. Finally, I'll say we did make a real serious effort to settle this, and it didn't happen. My client, I say gave, and they gave, but I think Mr. Unger gave a lot more because when we left here, Mr. Timothy said, get this thing settled. So we tried our best to settle it. It just didn't go by the wayside and we ignored it. I don't think our final offer is that difficult, but the answer we got was no, nothing. So if you're going to do this Cartway, as I know you must, we request that you do Route 1, that gets into his property, and award damages of $63,000. That's consistent with your comprehensive land use plan and with the WINC environmental report on the protection of the trees. If you go to Route 2, I don't see that you have any basis other than the $125,500. It's what you would have to pay if you were going to build this road, and your taxpayers would have to pay it. So I'm open for questions, if anybody has any.
Maybe not so much a question, but a comment, is how you could say that Route 1 has least amount of damages when it runs through wetlands is a little bit concerning to me. And your comment as far as mature trees, on our on-site, if you remember, we did visit this property. I think the largest tree on Route 2 was probably 6 inches in diameter, if that. So I don't agree with some of your suggestions at all as far as damages and the best route. So,
Well, if you start granting cartways to people because they can't get to some part of their land, they get to part of it, but they can't get to all of it, you're going to be doing a lot of cartways. He can get to his land. There's nothing in the statute that says you have to get a cartway to all the land. It just doesn't say that. So Route 1 gets him to a substantial part of the land. The Wink Associates report says the route, this is Route 2, would result in a higher density of trees than Route 1. This forest includes ironwood, oak, maple, aspen trees, and is a healthy part. Community, no beaver damage to the trees was observed. There are fewer dead trees. Because this road crosses a large undisturbed forest, it would result in more significant fragmentation of forest plant community than would Route 1. Fragmentation of plant community would adversely impact wildlife habitat. Exactly, this is what your comprehensive plan says you're supposed to try to avoid to do. And that's what Route 1 does. So,
Any questions?
Mr. Chair, if I might, do you know the distance difference between Route 1 and Route 2 on the yellowed trail marks up there?
you know, I don't have that information. No, I don't have that information.
Because it's, you know, it seems like it's almost twice as much for Route 1 and as compared to Route 2. And when we start talking about cost, even though there may be a few more mature trees on Route 2, there could be a material cost difference in terms of the length of what we're dealing with on Route 1. That would be my observation.
The cost to build, you mean? No, the damages are greater for Route 2 because you're closer to the, right down where it says Route 3, there's a house down there.
Right.
The proximity to that house, that's the damage, that's the severance damages that you would have to pay to a property owner.
Who controls the level of the wetland?
I'm told there's a culvert somewhere in there. I don't know who controls it, but
there-
I'm told there's a culvert somewhere by that red, and that has some impact on the road.
On which road? On the
On
red,
the,
the red
on
one?
the, on, I'm sorry, on the amount of water in that wetland. I was told it wasn't much of a wetland until the culvert was put in with the road years ago when you could do that.
Right.
And so that culvert, I guess, controls the water flow down through there.
Okay. No other questions?
All right.
I don't have a question for him. I've either got a question for our county attorney or our county administrator, whoever knows the answer to this. So just refresh my memory. Where are we at in this process? What happens is you choose the route and then you take care of the damages, correct?
You did some things before that, but at that point in the proceeding, that is correct.
So, remind me, did we choose the route?
When I went back and looked at my notes,
Yes.
on May 10, 2022, Route 2 was selected,
Okay.
and that's the Route 2 that is on that map. I do know that there were some, it's not a finalized thing, as Mr. Meyer says, until the final order, the final resolution selecting the route in order for damages is done and recorded. And so you still have the ability, and I've spoken with both attorneys, and I think both attorneys would agree that you still have the ability to change the route should you determine to do so. That's why I started the way I did, Commissioner Coring. I didn't know if there's interest in reconsidering that or not, but again, that's the board's decision.
But where we're at, Mr. Chair, so where we're at now is the board has chosen Route 2, and really, in essence, unless there's a motion to change the route, then our next step would be to put some damages on the route that we have chosen, correct?
Correct.
Okay.
So is that all the questions for now? I think we should
That's all
hear from
for now. I just
Kruger.
kind of just wanted to
Sure.
figure out
Where
where
we're
we're at and what our next step is.
Right.
Could I ask one more question of the board before I sit down? To be very clear, whatever you do today in the Cartway procedure, Mr. Ryan or somebody will then draft a Cartway order, and then it's signed, and there's appeal opportunities here. and that's when the appeal will begin. Am I correct, Mr. Ryan? That's what will happen. Whatever happens today, you'll draft an order to be signed.
If the board asks me to do that, I would be happy to do that. And Mr. Meyer, I know you're one of the experts in the state, so I'm not going to try to question your
Okay,
opinion on
that's
how the
fine.
law works. So.
There's a short time to appeal, and that's why I want to be very clear that until you sign the order, the cartway is not finalized, and then the appeal time begins from that signature. And then secondarily, whatever you award for damages, I ask that you require that to be deposited before you sign the order, so that the money's in the hands of the county administrator before you sign the order. Thank you.
Mr. Kruger, would you care to?
I'll let David go first because he had the bigger file. Good morning. It's a pleasure to be here this morning. Thank you. Pat Middleton would like to address the board with your permission before I do so, if that's okay.
Sure.
Thank you.
Good morning.
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 Could I hand this to the board also?
Sure.
There's some pictures this is the same set of pictures I just handed David. How many copies do you have? I gave you one of each and then, if I wanted to put up, anything else, is that a projector that you can
Yep.
lay it on? Okay.
So I'll try to do these in whatever order you want. Okay?
Okay, those are for the pass around for the board, but you can put them up, if you put them up, then everybody can
Put
see
them
them.
up, then everybody gets to see it.
Yeah, and you can pull those apart. Well, again, good morning, and thank you very much, commissioners, for our time. And I know that your time is valuable, and hopefully we can get these things solved in a short order here. When we left the meeting on 5/23, we were encouraged by the commissioners to work together as owners in an effort towards the private easements with the goal of keeping Marsh Point Road private road versus a cartway. I'm happy to report we have agreements with all owners keeping Marsh Point Road private road entering up to Mr. Unger's property. Unfortunately, as David had mentioned, we have not been able or successful in reaching an agreement with Mr. Unger. But if you look at, if I can hand you this, it just shows you the easements. There's 5 easements that we have from 105, County Road 105 to where it hits Mr. Unger's property. So including an easement from the county, and then there's 3 owners. There's Darren Huffman, Mike Antonson, and Al Workey of LGM Properties, and then Dick Harrison. And so there's 5 easements on that red line there that we've obtained. So, and actually the owners have been very, very good to work with. All these other owners have been very good to work with. Oops, did I just ruin your mic here? There was a question about, who controls the access to and the level of the water of the dam there, the pond. And that culvert is owned and controlled by Mr. Unger. And I'll get to that here. Let's see here. In fact, if we go back to, can we go back to the map that you had up? It's actually a better one because I think it's got all 3 options on it. And there's just something I wanted to point out here, but in my narrative, I've got another topic that was left open after our last meeting was the proposed access location of the easement across Mr. Unger's property, accessing Nelson Lake Preserve property. There were 3 access points identified on the last presentation marked 1, 2, and 3. Nelson Lake Preserve has never suggested option number 3, and we're not sure why that was on there. But the only one that we've ever suggested would be number 2, because it's the only feasible option of getting into our property. The option 1 is impossible without building a bridge across that swampland. But Nelson Lake Preserve owners feel the only meaningful access is the south of the pond, and that access point is 360 feet north of Mr. Unger's cabin. So what I did is I gave you a copy of pictures from that access point looking up at his cabin, and you can't see it. And we had a rangefinder and everything, and we were there with the surveyors that day working on where the number 2 route is, the yellow line. That's 224 feet long. Somebody asked the question, I know what that length is. I don't know what the length of the number 1 is. I've never measured that. But this is 224 feet. And we were trying to take a rangefinder from down there, and we couldn't get the distance because we can't see it. You can't see it. And even the surveyors had mentioned, is there a house up there? And I said, yeah, you probably have to go up the road to see it a little bit and this was, in the springtime, so all the foliage wasn't in, but you can see from those pictures, it's really, thick woods. So, again, we feel that, that number 2 is really the only option for us to be able to get into our property, for it to be a meaningful access to our property. Again, number 1, it's almost, if you saw it, and this picture, the water level is actually low here. When the water level is normal, that point that sticks out is usually underwater. I mean, you'd have to have chest waders on to even get near that spot. But if you're thinking about taking a truck or a 4-wheel drive truck in there or anything else, there's no way. You'd have to build like a 300-foot bridge, across that swamp to get to any land to land. I mean, it's just, it's not even feasible. So, and I mentioned to you that the water level is controlled by, the culvert is right down, just up from the number 2 access there. And there's a culvert that is controlled by Mr. Unger. And that's why, if that isn't maintained, or it's just, we can be flooded out at any time. And, you can't count on what the water level is going to be so that's why number 2, it makes sense that we both have the same access so that we're watching that water level to make sure that it's not overtaking the road in itself. So that's the other reason that we would like to see number 2. Again, as I mentioned, it's 360 feet north of Mr. Unger's cabin. I know that there's been privacy. There were statements made about privacy in some of the meeting that we had here. But if Mr. Unger was concerned about privacy, I guess the question, begs the question: why would you build your cabin 10 feet from our property line, where there are no trees? So he's 10 feet off of our line, and he had 680 feet to choose from to build his cabin. Why? He's got 2 lots together. But, why this thing was, set 10 feet off our line is just, to us, it just didn't make any sense. So, and I know that in the discussion with the Cartway, the damages, there was some discussion about screening. And the screening just didn't make any sense to us, but, it's as well as, assessing the Cartway damages, I hope it is understood, number 1, that Mr. Unger has had unauthorized beneficial use of our Nelson Lake Preserve property for over a decade. So he has been using our land for a decade and has kept us out of there. And we had told him that he wouldn't be welcome to trespass on our property either, because he had told us that we couldn't access anymore. We said, well, we would ask that you not access our property either. And also, at that time, that we had asked if that he would clean up some of the debris that he has on our property. And that's the other set of documents I gave you, is that from the aerial view, if I can give you this to, here you get an idea of how close that cabin is to the property line. And you can see that there are no trees and between.
Mr. Chair, I just have a question of how is this germane to picking a cartway route?
I mean, as far as
where his house is,
well,
relative to
no,
the property line, how you guys have had disputes over who's using
now
whose
I want to talk
property.
about the damages.
How is that relevant to the cartway?
I'm sorry, how is this relevant to having a cartway?
Yeah.
Well, we can't come to terms with Mr. Unger on a private easement.
Right.
And so the rest of Marsh Point Road, we believe, will be private.
Right.
As I pointed out. Because we can't seem to come to terms with Mr. Unger, it appears that this is the only option we have is a cartway. Right?
Yes.
So, and he's not willing to negotiate
And
that.
and you know what, I'm glad that Mr. Hool stepped in, because I think you're plowing old ground. You know, I'm an old farm boy, and
Okay.
I think you're plowing ground all over again, and I don't think it's helpful.
Okay, I didn't know where this was at as far as.
I think it's just what I just talked about. It sounds like the board has chosen Route 2, and I think we either have to, if we're gonna change that, this is where we'll do it, and then we're gonna set some
Okay.
damages, and I think, I don't know about the rest of the board, but I'm about ready to make a decision here.
Okay.
And, you know, and whether his house is 10 feet from your line, that's immaterial to this discussion.
Okay.
Does that make sense?
I apologize. I thought
okay.
I thought there was still debate over
No,
one
I don't
and
think
two.
there's any debate.
And so I just wanted to make it clear again from our point of view that we just feel very strongly that the only option for us is two, or that it would be a meaningful access. Is it okay to talk about Cartway damages?
Sure.
Is that all right? Because that's what the slide that I gave you is what I was headed. You know, while assessing Cartway damages, I hope it is understood that Mr. Unger has had unauthorized beneficial use of our Nelson Lake property for over a decade. Nelson Lake Preserve property is also being used as a dumping zone by Mr. Unger. The debris field can be seen from Crow Wing County aerial photos. And the one that I just gave you, you can see on the property line all these kind of, and so, yes, so here you can see the debris kind of that's piled up, and in this, the debris that's far left here, you can see a shell kind of casing. That is like an old camper that got burned up, so the casing there, that is 85 feet into our property. 85 feet. So it's not like it's just over the line. It's well into our property. Now, we haven't had a chance. Some of the pictures I gave you were when we were there with the surveyors, and we gave some close-up shots of what some of this stuff is that's on the property. And it's, to me, I think it's a real problem for all of us, because this needs to be cleaned up. So it's that he's using the property. He's using the property for his own benefit. And the worst thing he can do is try to get some type of settlement for him, because I think he benefits from not having anybody having access to our property. You know, there's this debris field, like I said, it reaches in like 85 feet that we can tell. We don't know, we haven't been into our own property to be able to assess how much more is in there. You know, and then there's this old saying that, well, even if the sink is included in the I'm sorry, everything but the kitchen sink, the old saying. Well, there's a kitchen sink in that mess too, in that pile that, you know, it does include a kitchen sink. And then it also includes construction materials, trailer or car frames, you can't tell what they are, a camper shell, yard waste, which is that big spot there, where it says second assessment, That is all yard waste, where he's dumping yard waste all the time.
So, sir,
Mr. Chair.
are you arguing that because Mr. Unger has had use of your property, the damages for the cartway should be reduced?
Well, I think they should be considered that he's not the only one that has damages.
Yeah, I don't know that we're going to be able to take any of that garbage or encroachment issues into account. We're just picking a cartway today, and the damages have to be related to the
Okay.
cartway.
If I may,
And so-
Mr. Chairman, I have a slightly different opinion, Mr. Hool.
Okay?
The trespass is not an issue. You should move on from that, okay? That's a civil issue, in my opinion, between you and Mr. Unger. However, if Mr. Unger or someone else has deposited debris on Nelson Preserve land that we are going to require to be cleaned up because of a hazardous waste or a planning and zoning violation, that could provide a direct benefit to the person who put it there. And one of the things the board's to consider when establishing a cartway is a benefit to the encumbered property, which would be Mr. Unger's. From that somewhat unique legal perspective, it may be relevant should the board determine it is. So a little bit of leeway may be allowed, but the trespass issue is a dead horse. Okay?
Okay, all right, thank you.
Commissioner Coring?
I guess Don, you're gonna have to elaborate on that a little bit. So if it's deemed that it's, needs to be cleaned up, then what, can you go into that again?
Yeah, so if I have a piece of property.
Yeah.
And I take and throw, we just had a public health abatement deal.
Correct.
And I create that situation, and then the county goes and cleans that up. If the landowner won't do it, then we assess that back against the property owner, their taxes. So there's a dollar value. I'll just use the sum $100 because it's simple to turn.
But it would be on the Nelson Preserve because it's on that property.
And so if Nelson Preserve goes in and cleans that up and pays for that,
Yeah.
they could then sue the person who put it there in civil court to try to recover that money. But because theoretically, if they're compelled to do that and it costs that $100, that's $100 Mr. Unger ultimately may not have to pay or would, unless he goes to court. So you could consider it at a benefit to Mr. Unger and his property as part of the cartway and take a certain amount off of the award you give them and then tell the Middletons they have to clean it up and Mr. Unger's still paying for it. It's
A roundabout way to get there.
So can I
Yeah,
say?
yeah.
So in looking at what the Land Services Department has presented to us, where there's $15,000 for screening, so the board could consider reducing that amount of screening because the Nelson Preserve people are going to have to clean up this mess. Is that kind of?
No, I would, depending upon what you do, however you determine the damages to Mr. Unger's property, and there are damages, then if you choose to do so, would consider if, because of this cartway process, there's a benefit to Mr. Unger. Now, typically, in my reading anyway, and I have two attorneys in this room that know way more about cartways than me, so I'm sure I'll be corrected if I'm wrong. The typical example I'm aware of is Mr. Unger owns Lot 1, the Middletons have Lot 2, and Mr. Unger has Lot 3. And by forcing a cartway through Mr. Unger's property on Lot 1, somehow he gets access he didn't have otherwise to Lot 3. There's a value there. And so then the board is to make a determination if there is a value, what that is, and deduct it from the damages. And all I'm saying is, only in regards to the argument that the Middletons might be forced by Crow Wing County to clean up debris, that may pose a benefit to the burdened property that you could consider in the grand scheme of things. That's all I'm saying. I'm not saying you have to do it.
So we could deduct money from the,
So that what you would do is deduct it from the overall damages award, but leave the award the same. So for instance, the screen, that would still be with the example up there, the 33 and change, and then if there's a benefit, you would take that off as a benefit to burdened property and come up with your new sum.
I understand. Thank you.
So I think we've kind of crossed into more of a civil action, and we should focus today on what our responsibility is, and that would be selecting a route in damages. And then, of course, obviously, there's going to be further work get cleaned up, but that is out of our hands, that part of it, unfortunately. It's quite a mess, but with that, we should probably ask for any discussion from the board, if there's any questions for Mr. Middleton, again, pertaining to the route and the amount of damages. And I guess I'll only add one comment too, looking at those photos. I'm not sure what good screening would do in this case, because it's so thick already that it would be just nothing's going to grow as far as screening goes. I could support screening if it was Route 3, but 1 and 2, there's no. And I made it a point to look from Route 2 when we were out there. You can't even see the cabin. So I'm not sure what good screening would do. So I would, hopefully we can consider reducing or eliminating that amount in the damages.
Does Mr. Kruger have anything to say?
Pat, did you have anything to add? Or? Sure.
Yeah, thank you.
Yep, thank you.
Thank you, Board. I think the relevance of what Mr. Middleton was talking to you about goes to the credibility.
Mr. Kruger, can you speak into the microphone, please?
Oh, sure.
Thank
I
you.
like to wander. My wife wants me to wander away. Anyway,
We can't help you there either.
what he was discussing goes to the credibility of the claim of damages. How can you claim I'm having all these damages when you treat your property like this? And that's what basically, in my mind, that was meant to illustrate, and for you to take into account when you're determining damages. Now, I understand the exhibit here was the land department came up with this for you, I believe. Am I taking that correct?
Pardon?
The land department came up with this?
Yes,
set of okay.
that's right.
First thing I want to say is Mr. Meyer talked about the need for an appraisal. And, you know, appraisals are sometimes obtained in an adversarial situation and sometimes not. I suggest to you that we have the appraisal by the county, the tax rolls. They've appraised this property. And it better be good, because I'm paying taxes by that, and so are you. And so I seem to think that that's pretty accurate work that they've done, and that's what I think we look at when you're determining damages in this case. Now, road creation, I'm not sure what that means, but the damages that you are to award is for the harm to the property that is caused by the creation of the cartway. What is the diminution in value? If the cartway doesn't affect that property at all, then there are no damages. And the case law tells us that there are situations where damages are inappropriate, or perhaps even the consideration of a portion of a cartway that crosses an existing road, as in this case, are inappropriate. So what you have to look at is, how does it affect the value of the property? You know, as citizens of this county, that a cartway in this situation has very little effect. Are there damages due? Certainly, but they should be fair and they should be reasonable. Screening, there is no need for screening. You can't see the house, period, from where this crossway goes. The screening would accomplish nothing. So what is the diminution in value in terms of screening caused by the cartway? None. That's not a diminution in value. That would be an improvement to be added to the property. I don't believe that is proper. A new road, or road creation, or a half driveway creation, I don't know what those are. A half driveway creation, I don't know what that is. That is not diminution in value of the property. That's an addition of value to the property. My understanding from discussion with the Middletons is that's driveway from where the cartway exits to Mr. Unger's home. I don't know, but that's not affected. That is not a proper consideration for damages. But road creation, I don't know what that is. Because a cartway is granted does not mean that any work has to be done on that cartway. You can leave it a two-lane path. You can do nothing and use it to walk into the property. There is nothing that can be required to be built because nothing has to be built unless the owner of the cartway decides that he wants to build something. And that's what I think you have to look at in this case. And so the only reasonable method of valuing damages, as I see it, is you look at the square footage that is going to be taken by the cartway, less the square footage that is already used for a road, and you determine the value of that square footage based upon the assessed value of the property. I'm not going to run through all of that for you, but 0505, the last four digits of the property identification number, if you take the house off of that, your value of what is going to be taken is $1,715. If you look at the other piece of property, which ends in 0503, that's 0.8 cents of an acre, and that's valued at $6,751 an acre, which comes up to roughly $5,400. That's the value of this loss. But from that, you have to take out the portion that is already used by the roadway that is there. And that comes to $1,446. 7 people use that roadway already. Excuse me, 6 properties use the roadway. We would be the 7th. So that damage, $1,446, should be deducted from that other price. I don't see any other damages here. I agree the junk pile is not germane to this discussion, but it is germane to how Mr. Unger feels about the value of property and how he treats property. And I think you have to look at his damages. And his damages are diminished by his example of what he thinks of his property or what he thinks of others' property. Thank you very much.
Thank you.
Thank you.
Mr. Chair, if I could just ask a question of Mr. Kruger?
Yeah.
Mr. Kruger, you threw a lot of numbers out, and I can't write as fast as you can speak. Ultimately, can you just slowly go through what you're requesting damages be determined at? Just give me the numbers. So you had...
First of all, to reach the numbers, I used the survey that the Middletons had performed, which gives me the square footage. Okay, so under the first parcel, which is 580405, that has an assessed valuation of $614,200. From that, deduct the evaluation of the dwelling, which is $525,980. The square footage that you're going to be taking up equals 0.292 of an acre, which with that evaluation would be $1,715 for the square footage of real estate taken up by the cartway that would be granted on that parcel.
I got that one, then you gave me another number.
The next parcel is 58040503, an assessed evaluation of $101,000. That's 14.96 acres, or $6,751.33 per acre. 0.8 of an acre would be taken up by the cartway on that portion of the property. That equates to $5,401.06. From those figures must be deducted the sum of $1,446 for the portion.
Just give me that number again, that's the one.
$1,446 for the portion of the roadway that is already there and is used by 6 other properties. Therefore, we should only be paying 1/7 of that. So if I take off 6/7, that deduction would be the $1,446.
So your overall request is $5,670.06 for
Correct.
damages, correct?
Yes.
Thank you.
What was that amount again?
$5,670.06. Thank you. I just wanted the board to be able to have a clear understanding of the number of your request.
Any other questions?
Nope.
Thank you very much.
No. I don't think. We have heard, I think, enough to, I believe, act on this.
The record shows on how to respond.
You did respond.
No, Mr. Chairman, I'm not arguing with it, but they brought up new matters that about were not ever addressed. And I'm entitled to make a record, that's all I'm asking.
What's the wishes?
I think we can acknowledge that he wasn't given an opportunity to respond. I'm comfortable with that.
Yeah,
And then we move on with the
I believe so.
I concur.
All right.
So,
Can you state in the Cartway order that you drafted to, please?
Pardon?
Could the fact that I wasn't given an opportunity to respond be reflected in the Cartway order that you signed?
Sure.
so,
Mr. Chair,
Yeah.
I'm not sure that we will do that. I'm not sure we will. I think you do have a record. It's here. We record these. And so you can and should feel free to use the publicly available record of this meeting to make whatever argument you wish. I doubt we should put into an order that we refuse to let someone speak when you have spoken.
Thank you, Tim. And
Mr. Chair, if I might clarify, I was only accepting his argument that in terms of our board minutes, not in terms of any order that will be issued following our motion.
okay.
All right.
So Don, back to you. So, the order that's filed, is that filed at the court, or where is that filed? Or is that filed with?
Once it's finalized and signed, it would be filed with the county recorder
County recorder? Okay,
and the county administrator's office, because it's board action.
okay.
And for the record, also, we didn't do this when we started. You are not acting as the Crow Wing County Board. You're acting as the town board for unorganized territory.
Correct.
I know that was the intent from the beginning through the end, and
Correct.
that's what the order will reflect.
So, okay, so I guess I'd like to make two motions, and I don't know, if somebody doesn't like it, you can tell me, but my first motion would be that the county, well, not the county board, the town board of unorganized territory, what is it? Second Assessment District. I make a motion to reaffirm Route 2 as the route directing the county attorney and the county administrator to file the order for the Cartway. So in my motion, I'm reaffirming that the town board is choosing Route 2. Does that make sense?
and we'll act on these separately. So,
Yes.
We have a motion by Commissioner Coring to select Route 2 as the Cartway.
I'll second that.
We have a second by Commissioner Barrows. Any discussion? All in favor?
Aye.
Opposed? Motion passes.
Mr. Chairman, I'd like to make a motion to set the damages for Route 2. And we have an estimate that has been provided to us actually by the Land Services Department, and we've had actually estimates from both sides on this issue. And so now I would move, Mr. Chair, that we set the damages in total at $15,000 for the total amount of damages.
Motion by,
And if we get a second, I've got a question.
we have a motion by Commissioner Coring. Is there a second?
I'll second it for discussion.
Second
So
by
my
Commissioner
question is to somebody here, do I need to break it out in, can I have a lump sum, or do I need to break it out like it's broken out here on the Land Services estimate?
I don't know that you need to break it out on a line-by-line item, but you certainly can. That's why we provided it in that format. But you do need to make some findings to, support the amount of damages at the $15,000 as the resolution is pending on the board table right now.
Well, Mr. Chair and County Attorney, I guess what my findings would be is I've heard a lot of information from both sides on this. I've heard some numbers that I thought were kind of crazy, 63,000, 120,000 for the first route. I don't feel that those, in my mind, I don't feel that those numbers are correct. I just heard the explanation from Mr. Kruger, which in my mind was easy to understand and it was reasonable. But understanding that the other side felt that damages were higher, I tried to err somewhere in the middle of what the Land Services Department had put forward for us. And that's where I came up with that number. Does that make sense?
So we have a motion, we have a second. Any other discussion? All in favor?
Aye.
Opposed? Motion passes. There.
Mr. Chair, is it the request of the board that I prepare some proposed documents for review and signature? So I would prepare a resolution in order establishing the cartway and the award of damages for consideration. Once we have that document drafted and it's in a format and the wording is consistent with the board's wishes, it is my recommendation that you do not sign that or execute it until all of the money that you, at least the $15,000 has been deposited. And then once it's signed, that would then start the appeal period that Mr. Myers talked about. And I'll go back and, before I give you back that document, make sure I have all those steps in order so that we do it correctly, if that's acceptable to the board.
And I don't mean this to sound, but what is the timing on that document? How
I've
quickly
never
could-
drafted one, so I have no idea, to be honest with you. But I'm going to go back and work on that today.
Okay, I guess all I'm concerned is, again, this is dragged out for 3 years, that we don't.
No, your decision has been made. Once the document's done, I will coordinate with both attorneys on timelines to make sure everyone's in the loop, and then we'll get the document executed forthwith, or to the extent we need to, and proceed forward. So I would say for sure it will be available at your next board meeting, if not before.
But in the meantime, this is,
You, at this point, have nothing more to do than have the document finalized and executed.
what does this mean to the Nelson Preserve, though? Is this granting them the access now?
We'll see what happens if there's an appeal or not.
Okay.
Mr. Chair, what I might suggest is, you have an action that determined the route, you have an action that determined the damages. If you want, have a board action that directs the county attorney to prepare the order. And then it's clear that that's where the direction is. It'll come back to the next board meeting for your consideration. I do agree with Don, you should not sign or record the order until such time as the full damage deposit of $15,000 is made. I would note, there is already a deposit, and I don't recall how much it is. Okay, then we may have to refund a portion of their damage deposit.
Okay.
So just a question, Mr. Chair, for the parliamentarian. So are you suggesting that we have one more motion to direct the county attorney?
Just for clarity, if you want, for the record, it's up to you. I don't think it's really necessary. We do it all the time.
I am happy, at the request of the board, to prepare a resolution in order establishing the cartway and award for damages. That's the official title. And then there's also a notification of damages that goes with that. I'll prepare both documents.
Were my motions clear?
Very clear.
Okay.
I got it. Okay. The one thing you didn't establish is whether you wanted any damages awarded for county staff time, which is permissible under the statute. From my perspective, I'm not looking for that, but I do feel I need to bring that to your attention. It were in some of the previous documents we talked about.
You know what? I'm glad you brought that up because I actually think that is important. I think staff has spent a lot of time on this. So I guess I would make one more motion to include, and we don't know if it probably was more than this, but I'm going to make a motion, Mr. Chair, to have the county costs included in the $15,000 to the amount of $2,500, making the total amount of damages at $17,500. That's my motion.
All right, we have a motion by Commissioner Coring.
I'll second that.
Second by Commissioner Brecken. Any discussion? All in favor?
Aye.
Opposed? Motion passes.
I will include that in the paperwork.
Thank you. All right. You bet. Now, we will just take, as long as it takes me to get more coffee break.
Thank you very much, appreciate it. Mr. Chair, that's all I have for you today, if that's enough.
Well, thank you, Don. All right, next up. Yeah. Next on our agenda, County Administrator.
Mr. Chair, members of the board, there was no senior management team meeting yesterday for lack of agenda items. We don't meet for the sake of meeting, and so I'm happy to answer any questions that you may have about county government.
Mr. Chair, hearing none, I would make the motion to adjourn.
We have a motion by Commissioner Barrows. Is there a second?
I'll second that.
I was just waiting for something, but second by Commissioner Coring.